Bem-vindo a todos que estão neste momento connosco e que se vão juntando. Bem-vindos a este webinar do AI Act and the Future of Business. I think I'm going to take it over in English from here. So welcome to everybody who's joined us for this webinar this afternoon, the AI Act and the Future of Business webinar. Thank you all for coming. Thank you all for tuning in to see, to learn all about this important information that we have. So just to let you all know also, this is being recorded. So if anybody would like to opt out or to ask for the recording afterwards, we're more than happy to comply with that. And we hope the information that we provide here and the presentations, we hope you find it useful. And as always, we'll be doing a follow-up afterwards with the contacts of the speakers and also with the presentations. And on that note, I would like to introduce our speakers. So welcome to Dr. Sílvia Biscaía of BVA law firm, also founder of Exquisite Insight Compliance, and to Jorge Cabaço of the digital marketing agency Dengun. Starting this afternoon's proceedings will be Jorge. So handing it over to you, Jorge. And if anybody has any questions, please feel free to pop them in the chat. We'll also be doing a few little questions at the end, maybe not all of them. We might not be able to, but we'll definitely be looking at one or two if you have any questions. So Jorge, thank you very much, and over to you.
Thank you so much, Carrie. I hope you guys can follow me, can listen to me loud and clear. Thank you so much for having me, for the invitation. I must note this is a follow-on session from this morning. We had it in person. Was a really lively and exciting event. So I know what's in it for the cards. I'll keep it brief for you because there's like very relevant and dense information layer about the AI Act that everyone really needs to be very careful learning from Dr. Sílvia Biscaía. Well, as Carrie said, I'm the executive director at Dengun Agency. We are at the forefront of digital innovation and bringing AI to our customers, and that's the capacity I'm here in to try to devise what we believe it is AI, what AI represents for businesses today, and what it may represent tomorrow. Of course, trying to frame the questions that will be further on addressed by Dr. Sílvia Biscaía. So, without further ado, the first aspect that I would like to share is that AI is now not only a technology cycle, it's more of an economic cycle that is reshaping how businesses create this competitive advantage and drive value. We are no longer talking about the digital era like we did in the past. For 20 years, the competitive advantage was driven by digitalization, websites, e-commerce, automation, and data analytics. And today we are looking at something that fundamentally changing the businesses. There's a transition from digital to intelligence, whether artificial or human. That's what ultimately is driving the decisions. And of course, this is no longer about chatbots or automation tools. This is much more profound. It's about who controls, structures, and governs the decision making across the board. So that's the background, and that's why it is so decisive, so important at this stage to be considered. Having said that, let me just click it through to the next one. I would like to frame the three phases of AI evolution that you must be acquainted with. Firstly, we witnessed the automation phase, and that's where machine efficiency and replacing repetitive tasks across industries, that's where it all started. Essentially getting more visibility in the early 2020s, like with machine learning, with automation. Then we witnessed the augmentation phase with supporting and enhancing human decision making. Here we had the co-pilot coming to the fore, accelerating and augmenting human intervention. And third, systems making contextual decisions, like the state of the art we are defining, with set guardrails that allow them to operate autonomously. And as AI is moving forwards and towards autonomy, it begins influencing pricing, hiring, credit decisions, risk scoring. This means it directly impacts revenue for companies, margins, reputation, and ultimately compliance. And this is why governance and the AI Act, of course, becomes essential. This is the moment where we believe AI is becoming infrastructure. We are not talking about experimental initiatives. It's becoming operational infrastructure across hospitality and real estate sectors. And I'll tell you what, I'll bring the hospitality and real estate sectors because those are the cases we are developing the most here at Dengun at the moment, with alongside our customers. And what we've witnessed is that there's a plethora of industry applications in both resorts and hospitality and real estate. And the companies that win are not the ones that are using the most tools, are the ones that are integrating AI into their workflows, into their systems, and to their operational logic. For real estate, for instance, we are bringing in this conversational lead qualification. We are bringing in the automated property matching according to people's preferences, both the ones that are inferred and the ones that are declared. Buyer intent detection, it's also an aspect that AI is bringing in lots of value, and of course portfolio intelligence system, managing the real estate portfolio, both for developers and real estate agencies alike. On the resorts and hospitality side, the ones that are most active are the digital concierge that you may be aware of some. We are developing Wisden.io, which is an AI-driven concierge system that integrates with the PMS and ancillary services from resorts and hotels in order to provide not only dynamic guest communication, but also operational forecasting and predictive maintenance, helping managers derive with the flows and the governance of their properties. So this is really state of the art, and we are bringing in these to resorts and hotels worldwide. As I said prior, AI without integration only creates noise. It's not for the sake of getting in the most tools. It's about integration with existing knowledge base and the existing CRMs or PMS. That's what's fundamental to understand for a business to be engaging with AI at this stage. And the real strategic questions for managers and CEOs alike at the moment is not just what's the latest trend, what's the fad of the moment. It's about measurable advantage. Where does AI create tangible value in our business model? Where it brings in real value? We also need to address the control and integration issue. How do we integrate AI without losing operational control? Also, really important, accountability. How do we ensure clear responsibility and governance of data, how to keep always the human in the loop, how to protect customer confidence and reputation of our brands by providing controllable and setting the right guardrails to our AI experience, giving this brand trust, and sustainably scale. How do we scale AI capabilities responsibly over time? Having a set roadmap instead of a scattered approach to AI. So those are the real strategic questions that the managers and CEOs must be able to address at this stage. So the AI Act and the regulatory landscape, this will be dealt in very much detail by Dr. Sílvia Biscaía, but what I need to say to you guys, this is mandatory. It's super important. Europe is defining the rules of engagement for these systems, and rules are important because they bring clarity. They bring clarity for investors. They bring confidence for corporations to invest, and they bring trust to consumers. Okay, the AI Act is not just about compliance. It's about creating a mechanism for AI adoption at scale and a foundation for sustainable competitive advantage. It's what will provide the scaled adoption of AI with trust, with confidence, with less noise, and with more confidence for everyone. So, having said that, AI governance becomes essential. It's becoming integral part for every procurement process, vendor due diligence, M&A risk assessment, investor scrutiny, and also for brand positioning. Companies that understand this early will move with confidence by implementing AI with a set framework that is ensured and it's controlled. That's what we brought with our conversational AI products. They bring in commercial intelligence and they bring this to the market. As a provider, this brings us plenty of obligations, as you'll see, but this is super important for companies to understand the intent capture, understand the user flow, and when potential buyers ask complex questions, you are there to answer 24/7. You're there to act when the commercial intent is present. It's also, I'm listening, someone unlocked their microphone. I think it's Doutora. Doutora, you want to jump in here at this topic?
Are you talking to me, George?
Yes, I believe you unmuted yourself. I thought you would like to say something about this topic. This is more a commercial topic, like the revenue opportunity and the margin optimization. Those are really aspects that the conversational AI can bring commercial intelligence for companies. But with this brings lots of responsibilities. So we need to adopt as providers. We need to adopt response. We are listening to you, by the way. We actually provide this ability of observability. So the human in the loop for critical decisions, to always maintain this human oversight, the knowledge boundaries, clear limits on AI scope and authority, always connected intelligence across systems, not only CRM, but also PMS and all the relevant systems for the management of a company. And of course, having this transparent logic and also measurable outcomes. So all these 5 elements become integral part of responsible AI architecture, that it's not only desirable, but mandated under the AI Act. For us, there is a clear competitive gap ahead for the ones that the organization that treat AI as tactical experiments versus the one that look at it as a strategic infrastructure. The ones that look towards AI as something that will be entrenched on their business model and bringing in the competitive edge. So, having said that, the strategic infrastructure advantages that we foresee for companies, they lie mostly under customer acquisition, so accelerating the conversion rates when adopted right, also bringing in the operational efficiency, accelerating the sales velocity, increasing the speed from lead to close. Also, very important, something that already existed in the past with the dynamic pricing, with machine learning models, but now we can optimize it through intelligent pricing, smart and personalized journeys, and of course, accelerate the strategic and tactical choices by the company. So, having said that, there are three elements here: speed, structure, and trust that must be combined in order to have governance embedded from day one. For the leaders, here's like the leadership imperative. So the first thing from our side that we believe a company must have prior implementing any AI is having set internal AI policies, define the standards for responsible AI across all the organization. Then create and build frameworks for assessing AI solution providers. As Dr. Sílvia will illustrate, this no longer stays alone with the providers. It will be also on the deployer's side, the user side, and having a concrete compliance mapping, oversight mechanisms, and strategic roadmaps. Companies that build these foundations will not only comply, they will lead, they will take the leadership in times of structural change that compounds exponentially. The clock is ticking and the time to act is now. My final remark would be to highlight that architecting intelligence responsibly, it's mandatory. We are entering a decisive decade where intelligence, not just that anymore, will determine this competitive advantage. The companies that thrive will be the ones that architect AI responsibly, combining innovation with governance, speed with accountability, and technological capability with human oversight. Understanding this impact without understanding the law creates blind spots. Understanding the law without understanding the business impact creates paralysis. Together, these perspectives will create the clarity and sustainable competitive advantage that the business thrive for. And that was my introduction. Take it as that. Take it as an introduction, because the AI Act is so much more than this, and is, I would say, a guiding principle, a guiding light for us all to bring our businesses to the next generation. Thank you. I think you guys, I have a note here like my microphone was muted. I think you guys listened to me. Is it good?
No,
We had everything, Jorge. It was perfect. Thank you.
Thanks,
I got here a note like your microphone was muted.
No,
Thank
it was fine. And so we'd just like to double check. Dr. Sílvia, is your microphone unmuted?
No, I think it's. Can you hear me?
That is fine.
Yeah, now
It's fine now.
Okay, thank you, George.
Yeah.
It was
And
an
also
amazing
just-
overview.
And also just to, yes, we need to share your screen, please. And also just to let all the participants know, as we go along, if you have any questions, feel free to drop them in the chat and we'll try to get to as many as possible at the end. Time allowing, we'll get back to as many people as possible.
Thank you.
Okay, thank you very much, Doutora, and thank you, Jorge. Now, Doutora Sílvia Biscaía.
Okay. Good afternoon, everybody. Thank you, George. It was an amazing overview. Well, I'm a lawyer. I'm a consultant on AI compliance. I've been a lawyer on a big law firm for 20 years, and other 15 years I was the CEO of a Norwegian group in Portugal with business in real estate, hospitality, and others. And when the Norwegians sold the operation in Portugal in 2024, I looked at this fourth industrial revolution that we are living, defined by physical, digital, and biological worlds, artificial intelligence, robotics, quantum computing. I said, no, I have to know about this. So the first stage, me and my partner at Exquisite Insight, we took a course in the Imperial College of London, Executive School, about generative AI beyond business. So we learned how to work with the AI for business. And it was scary, transforming. It was one of the best experience I ever had, because it's amazing how you see how can you do work you would previously need take a month with a team of 15, and you can do it in one day. So it is really amazing. The society, maybe in 2-4 years, will be completely different that we know today, but also scary, because as I previously worked on criminal law and very connected with fundamental rights, my first idea was I have to know this deep in order to protect the society, in a sense, to have critical thinking and all of this. So I took an intensive course about the AI Act that was working together Universidade Católica Portuguesa, the law, and Instituto Superior Técnico, the engineers, because in this matter we all need to work together. It's something that goes beyond a single unit of knowledge. So, starting on the AI Act, so this is long. All of this has started the idea to just a minute, I'm trying to, okay. It's all fine there? In 2008, the European Commission, they arranged a high-level expert group on artificial intelligence, was established by the Commission in 2018 with 52 independent experts coming from academics, industry representatives, Google, SAP, BMW, civil society, and think tanks. High level because they reported to the Commission, the group had produced 2 key documents, the ethic guidelines for trustworthy AI in April 2009, which defined the 7 ethical principles that underpinned the AI Act. And these 7 principles that you can see on the screen, human oversight and agency, means that the European Union wants AI always to be with the human in the loop. Our AI will have to be technical robustness and safe. This means systems must be resilient, reliable, and secure throughout the entire life cycle. Privacy and data governance, the GDPR will be in the focus, because all training data have to be appropriate and secure, with quality. The transparency, it's other principle, so everyone must explain the systems. Well, it's getting difficult now, but system must be explained, their limitations must be communicated, and users must know they are interacting with AI. Also, the European Union wishes to avoid non-discriminations and fairness, wants to work for inclusion. We have also focused in societal and environmental well-being. AI must be sustainable and serve the well-being of people, and must be accountable. There must be mechanisms for auditing, minimizing negative impacts. These principles were then I think I have problems with my computer to change. Okay. So these 7 key principles are now the base of the AI Act. The AI vision, the European Union vision, always the human in the loop, human-centric and trustworthy AI. This means has to be lawful, ethic and compulsive, with the fundamental rights that define the European society at center. And the goal is for us to be a safety brand for European tech. It may take longer with such regulation, but in the end will be safe and more trusted AI. The UI Act itself entered in force in August 2024. In February 2025, entered in force the prohibit practices. Now, also since February, the AI literacy is mandatory, and the transparency rules too, and it's presumably will be in August 2026 the full high risk regime, and in August 2027 the legacy systems. But as we'll see further, this can be extended. So what is an AI system? Well, the definition is there, but the main word that you have to think about is infers. When it infers content recommendations decision can influence physical or virtual environments, it is AI covered by the AI. Simple rule-based automation, spreadsheets and databases and things like this, it's not included in the AI. It's more machine learning, deep learning, predictive analysis, generative AI. This is what includes sorry. So the key characteristics of this legislation is the risk-based approach, as we see later in detail. The extraterritorial application, so it applies to any AI system that is made in the US or placed in the European Union. It has to be covers all type of AI system, current and future technologies. Will be the same legislation and harmonized rules for all the 27 US states, and applies to providers, developers of AI system, the deployers, that is every company professional user of AI systems, importers, distributors, product manufacturers, integrating AI, also the representatives of companies, for instance, from the other countries out of the European Union. So they believe that, like the GDPR, this will have the Brussels effect. This means that the producers of AI, for instance, in the UK or in the United States, will not have different legislation. So when they have to use the legislation of the Act to operate in the European Union space, for sure they will take it as the goal or the rules for every will adopt. Otherwise, they are out of our market. So, what you need to know that is very important if you are a deployer or a provider is that this legislation, the AI Act, does not operate on its own. It's a framework of legislation, several acts, several directives that apply also to everyone that is a provider of the product of AI system, or a company in some case when, for instance, in financial sector have more obligations. So the data is for everyone, the cyber resilience mostly for providers, the product liability directive is for providers, but can be for deployers if the AI system was substantially modified. The network and information security directive is for both, if it is a public sector, important sector, or private company in public services. The Digital Service Act is for the provider, but also can be for the deployer that uses a platform using AI. The Data Act, it's about the data access and portability. So it's also for some providers. The Digital Single Market Directive copyright text mining for providers. The Digital Operational Resilience for the financial sector is the DOR. And the Annex 1, which is the harmonized legislation for some products that are high risk. It's a safety component, will be also imperative for the provider. Okay. The timeline for this will be, as I told previously, until August 2027, but the package that was proposed to the Commission that we know as Digital Omnibus proposal intends to extend the deadlines until December 2027 and intends to simplify not the obligations but the procedures to small companies and small mid-caps. Okay, so for better understanding about who is a provider and who is a deployer, the providers are the entities that develop AI system or have them placed on the UA market under their own name. They have heaviest huge obligations. And the deployer is, let's say, it's all companies that use AI systems to simplify. There are other roles, like the importer, like the distributor, product manufacturer, that use AI systems integrating the products that they manufacture. And here there is something to call for attention. The companies that substantially modify existing AI models with retraining, fine-tuning, technical change may become providers themselves with the same obligations. Okay, all the legislation is based on the risk, which means it's based on the use you give to the AI system. It's unacceptable, we consider to be prohibited if the practice or use violates fundamental rights, namely social scoring, manipulation, real-time biometric ID or emotion recognition at work. It's to be considered high risk when impacts health, safety or rights. We'll see in detail going forward. Limited risk is all I require user awareness, emotion recognition, deep fakes. These limitations is most on the transparency side and high literacy. And minimal risk is the low risk applications that we have today. Most business use AI on a limited or minimal risk, but can be a problem what you call shadow AI that we'll see on another stage. So, about the prohibited practices, the manipulation, dark patterns are deep designed to influence decisions that can directly offend democracy, for instance. The exploitation of vulnerabilities like targeting elderly, children, disabled, social scoring, public and private, like punitive employee monitoring, all forbidden, criminal risk profiling, predictive policing without facts. It's not the same as if used on a criminal person, because all the AI Act does not apply to defense or national security. So on military equipment for defense, for security can be used. It does not apply these rules. So facial image scraping, building database from internet or CCTV. I had here interesting case, the case Clearview AI. They had a database of 50 billion photos scraped without consent. they paid 1 million in fines across Europe until now. There are other cases, from case replica, i.e. companion chatbot fined for processing data without legal base and lack of age verification, also already fined in 5 million. The case GPT himself, 15 million in Italy, OpenAI fined for data collection without legal basis, lack of user information, no age verification. So these some tools that were purchased many years ago may now be prohibited. Emotional inference, network of school, biometric categorization, real-time biometric ID. The high-risk systems. We see if the system is high-risk system in two ways. First way is Annex 1 of this legislation. You have the safety components. It's harmonized legislation for many components for machinery and equipment, medical devices, toys, vehicles, lifts, gas, radio, civil aviation. These components, it's always to be considered high risk until exemption proven. We'll see after. The second way is when the case for what you use the system, if it is biometrics, critical infrastructure, traffic, energy, water, digital, education and training, deployment and HR like recruitment, CV screening, evaluation of performance with AI, essential service, credit scoring, insurance, benefits, law enforcement, risk assessment, evidence analysis, migrations and borders, justice and democracy. In these cases, the use for these cases is only considered to be AI unless. So basically, the key question is, does your AI make or influence decisions that affect people? Is high risk. The exemption, we might also, I call it the strategic trap. And why? Because it's possible to escape this clause of AI high risk when you will say that your system only performs narrow procedural tasks, improves the result of previous human activity, detects patterns without replacing judgment, or is only a preparatory test. The trap is that you have to document your assessment, reasoning in detail, register in your database before deployment, reassess if some system functionality change, keep documentation available for authorities. It's never possible, this exemption, if AI performs profiling of individuals, output material influence decisions, or don't have a meaningful human oversight. A wrong classification will make the fines enter in place right away. So it's the same of non-compliance at all. So if you want to use the exemption, use it very well and very well documented, and otherwise can be a trap. So if you are a provider of high-risk AI systems, you need to put all of these procedures in place, and there are a lot. You have to have a risk management system, continuously identify, assess, and mitigate risks. You need to have a data governance procedure so the training data is relevant, representative, free of errors, and complete. You need to prepare the technical documentation, demonstrate compliance, provide information for authorities to access. You need the record keeping of logs. You need very clear instructions for use for the deployers. You need a human oversight design. The system needs always to allow meaningful human oversight. Achieve appropriate levels of accuracy, robustness, and cybersecurity. And you need to establish your quality management system to ensure ongoing compliance. You have a journey in that case that passes through all of these. We must say that this is a huge documentation in any of the steps. Start with the risk management, data governance, technical documents, record keeping. In the post-market, you need to monitor, report incidents, update documentation for 10 years. You need to register before placing on the market in the UA database. You need to have the CA marking and draw up to a this declaration of conformity. You need a conformity assessment. Just 2 slides for the technical documentation, because in these two topics, many issues will arise. The technical documentation needs to be, one of the requirements needs to be explainable. So you need to explain how did your AI system got to that decision, to that whatever it takes. The problem is that this is may be easier in a linear regression system or a decision trees. Starts to be more hard on random forests. It's high on neural networks and is very, very high in large language models. As you may know, the large language models now, they improve themselves, they iterate themselves from the outputs without supervision of the provider. So when it's need to explain how it got to that decision or to that solution, sometimes it's getting very, very hard for engineers to explain. The explainability is getting harder. So in this regard, it's impossible to do this with lawyers, engineers, and data analysts. Another call is that start now, because even if the deadlines are extended to next year, not to August, all these procedures take long and may take easily 6 to 12 months only to prepare. Another situation that creates lots of challenge, it's the data quality that is required, because the data needs to be relevant, representative, with no errors, complete. It has to be mandatory bias testing for gender, race, age, disability. But the problem is that to test for this bias, you need protected category data, but the GDPR restricts it. So you can process special category data swiftly for bias detection with document safeguards. For this method, they are creating sandbox and free zones for technology to allow our developers in the US to be able to follow the others out of the European space. Now, going to the deployers' obligations, which is the deployers, it's all companies. When using high-risk AI systems, they have to use it according to the instructions. They always need to prove they have the human oversight, assigned persons with competence, training, and authority to oversee the AI. Input data quality, ensure input data is relevant and representative, where you control inputs. Monitor the operation, inform provider of any risks or incidents. Retain logs for a minimum of 6 months. Imagine you use, imagine a system of AI that for diagnosis in a hospital. You have to keep the logs for 6 months. Inform workers before deploying the workplace. Inform all the affected individuals when the AI makes decisions, as for instance for credit. And you need a fundamental rights impact assessment. The substantial modification trap is that if your AI system was substantially modified by you to use it, you may be classified as deployer and not provider, with the same obligations and all the procedures that we saw for the deployer. So this is the compliance journey of high-risk deployer. Before deployment, this is very important. The due diligence. When you ask your vendor, is the AI compliant? What is the risk category? What documentation will you provide? Who is responsible for what? get the answers in writing, and especially for both parties, for also deployers and for developers, this contract, it's getting more and more important to define very well who is then responsible according to the Product Liability Directive. So you need a fundamental rights impact assessment. You need to assign the human oversight, inform the workers. Then during the operation, use as instructed, input data quality, human oversight again, monitor and log. And after, you have always to incident reporting, inform the effects, suspend the defeat, and cooperate with authorities. So this is the same slide. The conformity assessment, it's possible to be done internally. In this case, you apply for the Annex 3. It's never possible for Annex 1, or in case of biometric identifications, when harmonized standards not applied, or you choose a third party. So, or you do the impact assessment internal, or you notify to be done by external parties. You have these two paths. If the AI the deployer uses is limited risk, the obligations are just labeling. It's more all transparency obligations. Users must be informed they are interacting with the AI system. Users must be informed when such systems are being used on them. Content must be labeled when it's AI generative as AI generative. Simple examples. If you interact with the chatbot, you are chatting with an AI assistant. If you generate and use for your business AI-generated images, you should disclose an image created with AI. A voice assistant discloses user assistant. The content is article was assisted by AI. All of this can actually be put in a AI policy where you can describe and leave on your website all the cases that you use and for what. But even though the providers are obliged to label, in this case, to label the use of AI. It's one of the transparency obligations. The AI literacy requirement that is enforced is mandatory for everyone, both the providers and deployers of AI systems should take all the measures to extend a sufficient level of AI literacy for their staff. Nobody is doing this. It's incredible because it's enforced for long. And even if it's not defined fines for this non-compliance, you may incur in liability, normal liability, if this can cause some harm. So needs training, anyone operating AI systems, anyone supervising AI use, management making AI decisions, HR, legal, IT departments. And this becomes urgent because we know that now 78% of employees used unapproved AI tools. 7% use personal accounts without oversight. Only 7% have each trained. This is the shadow AI. When you don't provide in your company the AI literacy and you let your employees use private or personal subscriptions to AI, this can really cause real harm to the companies. First, for data, they might be probably using non-paid subscriptions or even paid by default. The data can be used for training if you don't opt out. So another problem, if they don't know what they are asking the AI, they will never understand the hallucination, the incorrect facts, the prompting engineer. So it's, I think it's mandatory because it's really something very neat. What is Well, when we do provide AI literacy training, when we go to a company and provide this, we explain what is actually AI, the essential concepts, types of AI, how work in business, what works, what does not, where it fails, how to identify and access bias and hallucination risks, what are the prompting's best practices, the AI relevant tools for the industry, hands-on exercise using real scenarios, when to use and when to not use, protecting personal confidential data, UA Act legal obligations, how to build an internal acceptance use policy for AI and avoid shadow AI, team maturity assessment before and after. Along with these, our law firm also provides the policies, the regulations. So both the Exquisite Insight and BVA gives this and prepare the company for responsible governance. When you need customized solutions, we will tell you to talk to George because he can really improve business also in that regard. So about why it's so important to have policy and regulation. The policy AI literacy is mandatory, so you need to have proof that you give this training to your staff. You need liability protection, prove due diligence if issues arise. You need transparency, know AI uses across the organization. The risk management, cast high risk before you have problems, consistency, same rules. It must include the AI inventory, the risk classification, the roles and responsibility, the approval process, training requirements, and dissident procedures. So this, of course, it's a tailor-made solutions that applies to companies by number of people and then by type of risk that you may have. Entering the general purpose model is a model trained with large amount of data using self-supervision at scale now because they iterate and improve themselves, capable of performing a wide range of tasks in different, you may always know them by the most known models like Claude is not a model, it's a system, but GPT and some. This obligation will not enter in deep because for the providers of GPI models, the obligations, it's a full documentation making, development, training, evaluation, traceable, information to downstream, transparency reports on capabilities, limited risk, copyright policy, training data. And for the GPI models with systemic risk, that is the capacity they have, the requirements and the obligations are even heaviest and additional, but for now we might talking about 5 to 15 companies worldwide that have high-risk systems or provide high-risk systems like OpenAI, Google, Anthropic, Meta, and so on. So the GPI in the copyright frontier is that if they must have technical documentation, information for downstream providers, copyright compliance policy, training data summary. The systemic risk ones, model risk evaluation, incident reporting to AI office, cybersecurity measures. The transparency for providers and deployers of AI content of large language models, it's mandatory. So you need to disclose AI generated by text or audio, image, video, as we talk about, deep fakes. Of course, this creates situations very complicated. Who use it and who create it, and well, but we don't have the time to go deep in this. And the chatbots, people must know they are talking to a chatbot. So here by industry, you see that the most risky sectors, it's all that has to do with recruitment and human resources, finance, insurance, and healthcare. When it comes to professional service, hotels, tourism, retail, and commerce, it's probably limited low risk and medium, perhaps, or can be, the chatbots can be a high risk. if not controlled. So here is a summary of penalties. This percentage is on the turnover, not revenue, it's turnover of the companies or groups worldwide. So the system is like the GDPR was. When I was running a hotel here that was owned, the management company by the Norwegian group, I didn't sleep for a while because any mistake that my team could make concerning the data would incur similar penalties to these ones for the group that owned Royal Caribbean, the one of the biggest in the world, for all the turnover. So you can see it's the same. Any risk can really incur in huge fines. So the common mistakes you should avoid this is just software. It does not apply. It applies regardless of terminology. We are just users trap because you have one obligation, the deployers have one obligation, the developers the others. It's low risk, okay, but you need required documentation to say it's low risk. We'll do it later. Compliance takes 6 to 12 months. Our provider handles compliance trap. They do, but you have to do also. So common mistakes. Steps for action. Create the inventory, identify people, address high literacy. We can help by for instance, we'll show you the possibility to do a free assessment. The free assessment that was prepared to analyze your level of risk, you just enter on our website and answer the questions. In return, we will send you a report, a simple report saying if you are low risk, limited risk, high risk, and what are your next steps. So if then you need our help, you'll have to contact us because we only use your email to send you the report and nothing else. So we can develop the strategic roadmap, the governance design, the training problems. On the law firm, we can do the legal compliance of policy regulations that applies to the Act and other digital regulation for the European. And if you need support in process automatations, tools integrations, platform development, so you can count on George, and I think you can build trustworthy AI.
Thanks for the mention, Sílvia.
Yeah. So I will not stuck on this because George explaining amazingly how it is a competitive advantage. You want to have an AI that is secure. The compliant vendors are preferred in procurement. The consumer trust increased value. The ESG now includes AI governance, so it's in an investment in the compliance. It's an investment in your business. In talent, it's always advantage. So Portugal created digital strategy that I leave here some notes. This will take time for the funds to be available. They are very, very connected or intended to help innovation and providers of systems. They want to create sandboxes for taxing and digital skillings, but it's a good initiative. Let's see if it works. So some key resources if you want to know more, but there's much more as you may imagine. And here I leave you the QR code, or you go to our website or use this QR code, you enter directly in the assessment. You answer a few questions. This takes like 5-10 minutes, can be 15, depends on the organization, if it is simple, if it is not. We identify your AI risk, understand your compliance, and we'll send you a report saying, well, you are low risk, you just need AI literacy or a policy, or you are high risk and you need to go through all the procedures. Well, it depends. It's very easy to do. It's very simple. It's free. And well, it's our how do you say this? Thank to you for being taking this time with us today. So,
Great, Sílvia.
and
Great,
that's it
Sílvia.
for
And
my part.
it's really kind of you. I already took the survey, and it's really thorough and helps assess how we are complying or not. And yeah, it's a very useful tool. I hope everyone uses it because it's really important and well structured in order to understand the compliance towards what Sílvia just explained. And this is a really good compilation of something so much more complex. You don't imagine the appendix, the annexes to this legislation, so many things that you brought together so clearly. Carrie, we do have some questions here. May I go out and address some?
Yes, indeed. We have a couple that have come in. So I was, yes, just going to say if we could quickly just have a look at them and see if we can give them brief answers. Yes, that would be great. Thank you, Jorge.
Yeah, well, I read the ones from Susie. I believe this is Susie Steinhoffel by the depth of the question, and thank you for putting this out, Susie. Good to see you and hear from you. Long time no see. There are a couple of questions in your comment. And there are a few things to separate here. First, I would like to say that today's AI systems are not fully autonomous super intelligence yet. They are really highly advanced statistical models trained to on large data sets. They can simulate reasoning and language extremely well, but they, for the time being, they do not have intent, agency, or independent goals. Okay, we can educate them and instruct them towards those, but they are not acting as such. Second, that claim about the blackmailing its creators has been on the news for some time now, and it's for the best of my knowledge based on isolated research experiments, so where systems were under artificial pressure scenarios. So those are not real world autonomous behaviors. So we should not be concerned at the moment about those. Those are edge case stress tests, and they are not in production to the best of my knowledge. That said, your broader point in the comment, it's crucial. The speed of development is faster than governance, and has historically been so. And that is precisely why frameworks such as the AI Act are being created, and they are fundamental. And we hope that the Brussels effects that Sylvia was mentioning earlier, it's taking full force, because otherwise we are moving into a Wild West environment, and that will be really hard to control. And about the jobs, we are moving towards a new world in terms of jobs. Some roles will simply disappear. We'll see like translation. We've seen companies that were into the translation, or they dropped like nearly 90% year on year since 2023. So they are disappearing. But many will not disappear, they will evolve, and new ones will emerge. So this universal income debate is more a political debate. It's something that we of course are aware, but we are still far, in my perception, we are still far from a world where the human contribution is obsolete. Even in an AGI scenario, I think it's hard for the AI to replace humans. Hugo, if I may, I can address Hugo's Wild West scenario, and can you keep up, because he's also addressing this, Hugo? Carrie, may I go ahead?
Absolutely, Jorge, feel free.
Okay. Giving Sylvia time to rest because she had lots of things to go through. But about these is a great question, Hugo. We partly addressed this on the in-person moment we had this morning. EU approach with the AI Act is risk-based and layered. It does not attempt to regulate every AI system equally. As Sylvia stated earlier, we are setting aside critical aspects like the security, defense systems. They are not being regulated. Of course, they would mean that the member states or the EU bloc would be a sitting duck then. So it's not regulating that. It's mostly to secure the freedom and liberties that we know about Europe. It's to secure that each member state have national supervisory authorities. It's there also to make sure that the market has mechanisms in order to regulate it. So it's not like the red tap. It's making the market work in a sound way. It will not be perfect, we know. No regulatory rollout ever is. Like the GDPR, it was not perfect, but the EU at least is a bloc that has significant experience in enforcing complex frameworks, and it becomes the trend. Hence the Brussels effects. It becomes a trend, even if they call it otherwise in other blocks. But there is a GDPR in the United States. There is also right to be forgotten in other legislation. And this enforcement, it's really important for businesses, because this is what will frame the corporate due diligence, the investor scrutiny, and the competitor pressure. So finally, compliance will increasingly become part of doing business in Europe, and for someone that it's here creating stuff, it is a good pressure to be under, because it means that we are at least know the rules of the game.
Yeah.
It's the way I see it. At least we have like the Código da Estrada, and we are not killing us all outside. So that said, perhaps that is not the most popular of opinions, but that's my perception. That's my take on your comments, and thank you so much for showing up, Hugo. And it means a lot that you are also coming to the online version, so you have two shots on this topic today.
Yes, and thank you both, Dr. Sylvia and Jorge, for this morning's very engaging and interesting event, and also this afternoon. So it's been a very good day. It's been very interesting to hear everything you've had to say, and I hope that all of our members, acquaintances, all of the people attending these events have also, and I'm sure they'll have taken some very useful information for themselves and for their companies. So if anybody has any more questions, please direct them directly to one of our speakers. We'll be making their contacts available in an email following up this event. And we'll also be sending out the presentations and the recording. And if there's anything else at all that we can do, we'd be more than happy to direct you in the right direction and put you in touch with our speakers. So Doutora and Jorge, thank you very much. And thank everybody else for attending this afternoon. And we hope to see you again at another BPCC event in the near future. Thank you.